Good afternoon, everyone, and welcome to the first meeting of the Committee of Administration and Management to consider the recommendation on obtaining government records for use in agency proceedings. I'm Ayal Perdes, serving as the staff counsel for this project, and I'm joined by the project consultant, Professor Margaret Kwoka, and the committee chair, Professor Erica Litson. Before calling roll, I'll turn over to Kaja, the Deputy Research Director, to have our opening remarks.
Thanks, Ayal. Jeremy's just running a few minutes late, so he'll be joining us momentarily. Just want to thank you all for your participation in this, especially to Erica for chairing the committee and Margaret for an excellent report. Very excited to see how everything progresses with this project as well. Yeah, and if Jeremy has anything to add, he'll add it when he gets here.
Great. Thanks, Kaja. So I will call two roles. The first role will be the names of committee members and alternates of committee members. After each name is called, the person should say here, so we can make sure their mics are working. So the committee chair, Erica Litson.
Sorry, I'm here.
Perfect. Bernard Bell.
Here.
Bridget Dooling. I don't see her right now. Maybe she'll join us momentarily. David Lewis.
Here.
Thanks. Gillian Mesker.
Here.
Thanks. John Myrick.
Here.
Thank you so much. Aaron Nielsen.
I am here.
Great. Thank you for joining us. Nina Olson.
Here.
Thank you. And Angela O'Connell. I guess she'll join us soon as well. Is there any committee member present here whose name I did not call? All right. And the second role will be the names of ACUS members who are not on the committee and their alternates. Again, after each name is called, the person should say here, so we can make sure their mics are working. I don't see any member of ACUS that is not a committee member here, but is there anybody here who's an ACUS member who I did not call?
Oh,
Ayal,
sorry.
I just wanted to
Ayal?
let you know that Bridget showed up after you called her name, so I just wanted to call your attention to that.
Okay, thank you so much. Bridget, can you just say here so we can make sure your mic is working?
Yep. Hello, everybody.
Great. Thank you so much for joining us. Okay, please reach out via the chat function or email if you experience any technical difficulties during this meeting, and ACUS staff will be happy to assist you with troubleshooting or moving to alternative means for participating. And now I'll turn to Erica to start the committee.
Thank you. So I'm going to read the sort of the standard ground rules that apply. And it looks like, do you want to, and Joseph O'Connell just joined. Do you want to have her use her mic to confirm? And
yes, that would be great. And can you please confirm, say here that so we can confirm your mic is working?
Sure. Can you hear me?
Yes, perfect. Thanks so much.
okay, so please note that only ACUS members, including government members and their designated alternatives, public members, senior fellows, liaison representatives, and special counsels, whether or not on the committee, and their designated alternates have full speaking privileges. To avoid background noise, we'd ask that you keep your microphone on mute and either use Zoom's hand raise feature or add a comment in the chat feature saying that you'd like to speak, not putting the substance of your comment in the chat feature. I'll then call on you and you can unmute yourself. Please then remute yourself when you're done and remember to lower your hand. I'd also ask that ACUS members and their designated alternates use their webcams to facilitate conversation. With respect to attendees other than ACUS members and alternates, participation requires the unanimous consent of committee members. Time permitting, I'll consider calling on such attendees at appropriate points, and we will presume that committee members consent absent their raising an objection. If any such participant would like to speak, please so indicate in the chat feature or again by using Zoom's hand raise feature and wait to speak until I call on you. You can then unmute yourself and please remute yourself when you're done speaking. For all participants, again, please use the chat function only to indicate that you'd like to speak, or for committee members and their alternates to vote when asked. Please do not hold any sidebar discussions or put substantive comments in the chat feature. Only members of the Committee on Administration and Management, including government members and their designated alternates, public members, senior fellows, liaison representatives, and special counsels have a vote. Please do not vote unless you are a member of the committee. Eyal and I have a list of committee members if you are unsure of your status. I am now going to introduce our consultant on this project, Margaret Kwoka, who is the Frank R. Strong Chair in Law at the Ohio State University Moritz College of Law. She focuses on information law, government secrecy, and administrative law relating to transparency, so she was the perfect person to write this report. And I'm going to hand it over to her at this point.
Thanks so much, Erica. And I just want a huge thank you to all of the ACUS staff and most especially Eyal for all of their help on this project and shepherding this to this point. It's been really a pleasure working with all of you again. So I just want to, I have, I think, 5 minutes or less, and I'm going to try to just do a couple of really sort of groundwork setting comments about the report, which I know you all have, so I don't need to sort of reiterate or do much summarizing. One thing I wanted to do was just to sort of talk a little bit about the scope of this project, what fell within it and what does not. So, you know, obtaining government records for use in agency proceedings can sound like a very amorphous sounding topic. You know, when I was thinking about the scope of this and working with ACUS staff on the scope of this, the first piece of scoping was really about defining what kinds of agency proceedings we're really talking about, what is at issue. And to that end, you know, we eventually settled on a scope that includes a large range of agency proceedings that are not rulemaking. So enforcement proceedings, benefits, decision determinations, and this, you know, all of those things that are both frontline decisions and then also appeals from those, licensing, determinations even about claims between two private parties that agencies may make. So there's sort of a wide range of types of decisions, and it covers all kinds of adjudication from, you know, if you want to go with type A, type B, type C, or if you want to go with formal and informal, or, you know, with a hearing, without a hearing, with or without evidentiary proceedings, all the whole scope of that. And partly it's because, you know, the law as to disclosure doesn't really differ much vis-a-vis the kinds of adjudication we're engaging in. So that's one thing, but it excludes rulemaking. So we're not talking about any sort of rulemaking procedures, the considerations of which are obviously very different. The second piece of the scoping question is, you know, what we mean by obtaining government records. I eventually concluded that there are sort of two important aspects to this question that are related. So the first is how it is that agencies themselves are gathering federal records that they need for their own proceedings. Sometimes that's from their own records and sometimes from other federal agencies that house records that are relevant. And then the second aspect of that question is, how are the private parties obtaining the records they need in order to navigate that proceeding, whether it is applying for benefits or defending against enforcement or otherwise? And those might seem like two really distinct questions, but they actually relate to each other, because the more work that the federal agency is doing to sort of build that record, the less work the private party has to do in many instances. And in some instances, the private party is doing the work more than the agency. So I just wanted to sort of name those scoping questions. On the methodology front, as you saw in the report, I canvassed sort of both primary legal sources and also secondary literature about agency proceedings. I also conducted a series of interviews with agency staff at a wide variety of agencies, and I eventually used 12 case studies encapsulating sort of a wide variety of types of proceedings and contexts to try to get a sense of how agencies approach this. And the final thing I'll say is that the report eventually categorizes agency practices for obtaining records for use in proceedings into, unfortunately, quite still a large number, seven types of practices. The first one is really about agencies gathering records themselves, including their own records or through usually matching act agreements with other agencies. And then the other six are sort of really about how it is the public is gathering their own records for use in those proceedings from the agency. So those practices involve formal administrative discovery mechanisms, informal information disclosures from the relevant agency official, providing access to records through an online portal or login, proactive disclosures related to proceedings or having a fully public docket, and then relying on the private party's rights under FOIA to access their records, and finally providing some sort of non-FOIA request option. So in the report, I try to detail the considerations that lead agencies to choose one practice over another, and that I think based on those experiences counsel toward some choices in some circumstances versus other choices, and how agencies might approach these sort of procedural design questions. I'm happy to take any questions you have now, or at any point during this meeting, obviously. And other than that, I am going to turn this back over to Erica for the discussion in the committee. Thanks again for the chance to work on the project.
Are there questions for Margaret about the report before we turn to the recommendation? Okay. All right. Seeing none, I think we should turn to the recommendation, which fantastic. Thank you, Eyal. So let's start with the text of the recommendation, and we can come back to the preamble after we finish with the recommendation. So I suggest we start. I want to make sure I can see all the people. All right. We start with number one, and I'll give you a moment to read number one and look for comments. Any suggestions, any questions? If not, all right. So number two runs to the top of the next page. And we can maybe take it bit by bit if necessary. So when determining how to make records available for use in administrative proceedings, an agency should consider the following factors. Any comments or concerns about A, or maybe any of A through D, really? D is a catch-all. Nothing?
I think I do. This is Nina Olson, and I do have a comment. I don't know whether this is the right point, but this is when determining, I guess this is about how, not whether to make them available. This is more about method, correct? Not about deciding which records you're going to make available.
Eyal, do you wanna respond on that? What I mean, when I
My underlying concern, and then maybe you can say this doesn't fit in. There in many of the informal hearings, there are unrepresented persons, and they may have provided records to the agency that the agency is holding themselves, but the agency may not provide that information back to the individual in the hearing. And if they're unrepresented, they may not have saved copies of their records that they've sent in or things like that. So I think somewhere in here, there needs to be a recognition that there may be private parties that need copies of their own records that have been submitted to the agency that the agency could then provide to them. And that should be a factor to consider, whether someone's unrepresented, low income, et cetera, vulnerable populations. I don't know that that goes in two.
Anne, are you responding on this, or do you have a different point?
I actually have a point on one, so whenever you want
Oh.
to come back to me, that's fine.
Okay. Bernard, are you also responding? Do you have a different point, or are you responding on the question of unrepresented persons?
I have a different point,
Okay.
and it's a wordsmithing point. I also have a question on one as well.
Okay, all right. Well, how about why don't we back up and do one then, because it is sort of introductory. Let's do one, and then we'll circle back to Nina's question about where we put any kind of consideration about records from unrepresented persons. So, Anne, you had your hand up first for number one. You want to?
Sure. I know this is about administrative proceedings, but I'm a little bit worried about the language when necessary in line 66, because under our statutes, it wouldn't, I mean, right, we could get disclosure and we might want disclosure for oversight and other things. And so I just wanted to raise that I understand you're not restricting what the statutes apply to, but I might say, and to private parties, I don't know, like, among other reasons when necessary for use in administrative proceedings. I don't know if anyone else has the same concern.
I wonder if that actually might be partly responsive to Nina's concern, because the fact that those private parties didn't have representation and might need them again in a proceeding could be one of those other reasons.
Yes, exactly.
Nina, do you think address the point
Well, I
you made?
think that's a placeholder, but I think somewhere we need to spell that out.
Okay.
And the reason why I'm saying that is that, in fact, it is the position of the IRS, at least at the appellate, at the Office of Appeals, and also when you're asking for an administrative file, the default position is that they don't provide the taxpayer's own provided documents.
Okay. Bernard?
Sure. So my question with regard to one is that there's sometimes disclosures are prohibited, or there's an exemption under established law because of the privacy of the person involved. And if the person involved is the person who's litigating, or who has a claim, or that there's an enforcement action against, then it wouldn't seem to make sense to withhold information from that person due to concerns about privacy. So I'm wondering whether we need to do anything to address that, or if it just kind of it wouldn't really make sense for an agency to cite privacy against a requester that is themselves the subject of the record.
Do you think that unless the agency is prohibited from disclosing the record, is that Is that gonna
I mean,
catch?
you could say except for privacy, for privacy exemptions or prohibitions, um, that, well, let's see, except when a privacy prohibition would be, um, um, but inappropriate to cite, I don't know, inappropriate to rely upon,
And I am
which is
not.
not perfect, but
Yeah, and maybe Margaret can answer this question, but if it were a privacy, would that not be, how does the law work there? Did the privacy restrictions don't apply surely when an agency is disclosing a person's own records to them? So would the unless prohibited by law, wouldn't that already capture or permit disclosure of a person's own things to themselves?
Yeah, that's certainly right. That an agency can't cite the privacy exemption to prevent disclosure to the person who's concerned. Agencies usually use a privacy waiver process, in which there's a form in which you sort of attest to your own identity or some other identity verification method. And then also the question may arise with regard to representatives. So a person who is represented by a lawyer or other agent who's trying to get their records on their behalf will have to get a privacy waiver from the individual. So I think Bernie's right, that we want to be sure that it's clear, right, that the law does not prohibit disclosure in those circumstances. I guess I defer to this committee and their drafting expertise to know if that's clear enough the way it is, or if it needs, an additional sort of line of specificity. I mean, there could just be another sentence that says, like, in no case should privacy be a reason not to disclose records to the concerned individual or their representatives. I'm not sure if that, I don't know what the right way to draft it is, but that's the answer to the substantive question.
Right, thank you. Bernie, do you have a reaction to that? Maybe a sentence at the end of that clarifies something along the lines of.
I think that would be fine. I don't have anything better than Margaret suggested off the top of my head, but this may be something that, requires some thought. So we could put in what Margaret said as a placeholder, and then with a note that we may be able to phrase it better.
Sure. Jillian, are you responding on this, or is it something additional?
No, on something in one, but earlier, so.
Okay, so how about if we put a sort of a placeholder at the end of the sentence rather than a sort of except after the unless, and just put a and we can maybe revisit it, but something along the lines of in no case shall, I'm trying to remember what Margaret said, privacy considerations. How did you phrase it?
In no case shall an agency withhold access to records based on privacy of the requesting party, based on the privacy interests of the requesting party. I don't know, drafting on the fly isn't my specialty either. Sorry.
Yeah, all right. It can be a placeholder and we can make it pretty later. Okay. All right. Jillian?
Yeah, I actually had a question. I think Anne's edit may have taken care of it largely in practice, but I was curious to hear from Margaret a little bit more about how necessary for use has been read, or how broadly. I may have missed this in reading the report, but whether agencies approach that more narrowly in terms of, these forms are actually required, or whether they take it more capaciously in terms of you have to prove something and the records would be useful for that, but there might be other records that could also be used. Just how narrowly or broadly is that understood?
Yeah, I might ask Gail to jump in here as this language came from ACUS, not from me, that phrase. I mean, I can tell you my own views about sort of like how it might work, which I'm not sure are completely encapsulated in this recommendation as it was drafted by ACUS, just because of this, you know, this is not my document. My own views is that it is appropriate for agencies to make records available to assist parties in applying for benefits, right? A lot of the pre-population issues. So for example, we have instances in which Social Security will go around and gather medical records on behalf of applicants for disability benefits in order to help them get their file complete. Now, obviously, it may be that at the end of the day, they don't qualify for benefits and the agency's, record gathering demonstrated that fact. And so it's not that it can never be disadvantageous, but that those uses of agency resources in gathering records, especially from other agencies, are the most appropriate uses of information sharing. Whereas examples that I provide in the report where there are concerns about information sharing are instances in which information is being shared for purposes other than for which it was provided originally, and being used in enforcement proceedings for which there is some type of, peril at the end, whether that is, monetary penalties, immigration enforcement proceedings or otherwise. So I think I think personally that there are different considerations, and I think the report demonstrates some of those examples, that information sharing for the purposes of helping applicants for benefits is sort of the most straightforward case for good use. Because the problem is that when we use information in a punitive way for reasons that it wasn't originally provided, we may be discouraging the provision of information voluntarily in various ways. So I don't know if that was, I'm happy to, Jillian, did that answer your question?
That was very interesting. I guess I still have, my concern here is whether we should be worried at all about when necessary for use being too narrow or too broad. And so hearing your background of the different instances is helpful for that, but I still am not entirely sure how it's used. I saw that Bernard had a suggestion on phrasing there. And again, I think Anne's, among other reasons, sort of eases that somewhat, although we still have the text in the recommendation, so we should have a clear sense about what it means.
Bernard, do you want to make your suggestion for?
Yes, so I put it in the chat. So basically, the proposal would be replace when necessary for use with for use in connection with, and then add administrative proceedings. So we take out the necessary, and essentially we're talking about producing documents for a party that reasonably wants them in connection with the proceeding. So that's the least way to get rid of the necessary.
Reactions? Nina, are you weighing in on this?
Yeah, I actually have concerns about that. I mean, I understand that we're saying in this provision, unless the agency is prohibited by law. And so there are many statutes on the books under every agency that says you cannot share certain information. But I am not someone who thinks that the broad sharing of information gathered by one agency for one purpose should be shared with another just because it's able to be used in connection with. I think necessary is a very important delimitation, and I think that's very important.
Can I get some discussion on this?
I think also to what Margaret had said, there's a lot of information that's gathered that's not fit for the purpose that another agency would use it. And that would be another point that somewhere in this discussion, I need to, I think we need to see that concept surfaced in the recommendations.
Thank you, Nina. Bernard, do you just have your hand still up, or are you?
I'm sorry, I actually did just still have my hand up, but just
Okay.
if I may, just
Yeah, I
to
see Jillian's
react to
call.
Nina's
Mhm.
point, which I take seriously. So I'm assuming there's some function that if a party is asking for information that is inappropriate for some reason, that the agency would have the power to say, well, we've considered your request, and we would provide it because you think it's necessary, but we think it's inappropriate here for various reasons, and so that's why we're not going to provide it. So I think it has to be appropriate, and that may be the way you appropriate records for use in connection with the proceeding, and that might be one way of indicating that there's some gatekeeping function here, that just because you asked for it doesn't mean that you should get it despite other considerations.
Mhm. Jillian?
I just want to say I'm not necessarily opposed to necessary for use. I just wanted us to think about what it actually meant and whether we wanted to make that. It just seems a value choice. I do think that the language that Anne put in about among other reasons allows for not limiting it just so we're more saying at least in this case you should provide it. We're not necessarily saying you shouldn't provide it in other cases, but we're not specifying them, which I think is quite helpful. But I'm a little happier with necessary for use if necessary for use means, not strictly necessary, but useful and sort of beneficial. And maybe you've got a party who can't easily find other documents. So necessary has both of those meanings. It's certainly a flexible term. So in that sense, it's fine to use. But I just thought it was a value choice we should be thinking of.
Okay, so we have two different directions here. One is to say for use in connection with and maybe modify it with appropriate or relevant or something like that. And then the other direction seems to be going back to when necessary for use, and sort of two different approaches. Are there other reactions to these options?
I can maybe jump in just on the ACA staff level. Where I know there was some questions. I think our understanding, and I think Ben can jump in if he has a better way to phrase this. We were thinking of this as a general statement about the principle of how we view when again records should be available to the parties in agency proceedings. And the idea is that there are so many records that agencies have, and simply not all of the records are necessary for use in agency proceeding, and we're not having a statement that all records whatsoever should be available. And I think it was to cap that specific aspect of records and records that are actually in use in agency proceedings. I don't know if Ben maybe has something to add on that.
Yeah, I don't think I have too much else, but I mean, I think one of the questions is, what does necessary mean? I think there's this question about, does it mean like strictly necessary, as like Jillian was saying, or is it kind of something broader, like something that's useful? I mean, based on my, kind of work on the recommendation and the review of Margaret's report, I mean, I think it's very challenging to define in the abstract kind of what necessary means, because and maybe I kind of tend more towards Jillian's view, which is that, parties might not know, or the agency might not know what it needs until it kind of conducts the proceeding. And so it might request more information than it ultimately needs. And so, I mean, I guess I would, if you're asking my view, I kind of think more about trying to not so much define what necessary means in a kind of abstract sense, but focus more on there's a variety of methods that agencies use. And we kind of look at the, just costs and benefits and burdens on the agency and the private parties about whether to use a particular method to disclose it. And, if a record is, potentially a party wants it, but it may not be, strictly necessary. Maybe it's even questionable whether it's even very useful, but the party still wants it. Maybe that's something that falls more toward like, a party-centered approach, like under FOIA versus something else. So, I mean, I guess I think it's challenging to define what necessary means in the abstract, and I would kind of focus more on like what are the different kinds of methods that agencies use and what might be the cost and benefits of using a particular method, depending on kind of the nature of the record at issue.
So what occurs to me is that when we struck out when necessary for use in and we put for use in connection with, we almost immediately had to start reinserting words to kind of cabin again, kind of tiptoeing our way back to some kind of gatekeeping, like the gatekeeping that was being accomplished with the when necessary for use. I mean, I haven't heard a consensus here. But, Margaret has a suggestion in the comments of relevant, and I wonder about something like when necessary and relevant or something like that. And maybe that will get rid of concerns that people are asking for things that aren't relevant. I don't know if you want both, but I think that we shifted from necessary and then we're starting to add considerations to kind of get us back to cabining it a little bit. I don't hear a consensus here, but about which approach to take. I'd be inclined to go with the original, the necessary, rather than for use in connection with, but I'm chairing, not making the decision. So, Jillian.
Yeah, I'd share your instinct that it does seem, I did not mean to open a can of worms, and it does seem to have gone a bit in that direction. Again, I think the more important thing is to have the caveat that we put in about among other reasons. So we're not saying the only time the obligation applies is when it's necessary. We're just not specifying other instances.
Okay. And let's bracket the appropriate as well, because I think if we go back to bracket it with relevant as the alternative that came from Margaret, and we'll revisit. We'll have an opportunity to come back to this. But Bernie, anything else on number 1? Go ahead.
Yeah, just briefly. What about instead of when necessary, when needed? Is that a term that is a little more flexible? Or does it not matter? I mean, I think it conveys that it's something that would be helpful to the proceeding, but doesn't imply some formal test of necessity, strict necessity, even relevance. So it gives the agency flexibility to decide what's appropriate. So that would be my suggestion.
Anyone else on number 1? Okay, let's move to number 2. So number 2 is, and I was reflecting a little on Nina's comment. I think number 2 really is about the how. So I think Nina, let's put a pin in your comment, and we'll figure out when that is relevant. I think it's not on number 2. So so when determining how to make records available, and then we've got a list of 3 factors plus the any other relevant considerations. And Bernie?
Very briefly on B, I'm wondering if an assertion of an as makes sense. So does when a particular method promotes fairer, more efficient, more accurate, or timely use of record in a proceeding as compared to other methods? And I don't feel strong about it one way or the other.
Yeah, I think that might be a style issue. The meaning, I think we all understand the meaning there, right? It's which is it's fairer than or fairer. Sure. I have no opinion on that. So number A, whether the agency is required by statute to make the record available using a particular method, whether it promotes fairer, more efficient, more accurate, or timelier use compared to other methods, whether it's less costly or burdensome to the government or private parties compared to other methods, and then a catch-all, any other relevant considerations. Any other edits or substantive concerns or anything anyone wants to feels it necessary to add to that list? Again, this is how to make the records available. Okay. So now we move on to internal agency procedures for making records available for use by agency officials. And we'll start with number 3. David, are you going back to number 2 or are you on number 3?
I am. Sorry, I'm slow on the hand raise here.
So number 2?
Yeah, and just quickly, I just for my own clarification, the way that I read these first 2 points is, one is like agencies should make records available. And I'm a little bit like, I guess it needs to be said, but I assume that it's already being done, and I suspect that there may be an ACUS recommendation on this somewhere before. So I don't know whether this is just repetitive of what we've recommended before. And then on the second point, like what we're really trying to say is pay attention to A, B, and C. And then we have this kind of catch-all of, and anything else that we should be considering. And I kind of feel like, why are we saying and anything else we should be considering when we really care about A, B, and C? Sorry, this is the political scientist in me speaking. Like, doesn't the statute already require that we make these records available? And why are we saying pay attention to anything we should be paying attention to? Because that's effectively what D is saying.
Well, let's start with the first one, the first observation, and I'll let Eyal or someone else from ACUS respond to whether there is prior ACUS work that addresses this issue. I assume there isn't something previously that basically recommends what number 1 recommends, but Eyal, can you confirm that?
If I remember correctly, there's not a recommendation with the exact same phrasing, but I think definitely the principle has been reiterated in some extent and from previous recommendations. So the language was inspired by prior recommendations. And Ben and Jeremy, I don't know if you correct me on this one or I got this right.
Yeah, I mean, I think there's prior recommendations, excuse me, that say bits and pieces of this, but probably not as comprehensively and as directly.
Okay. Right. Okay. So then just looking at number 2, and maybe this is actually a question more for Margaret than I mean, the ACUS folks can talk about why they thought it was important to say any other relevant considerations. But Margaret, do you think A, B, and C capture everything that would be appropriate to have here? That's to Margaret. Sorry.
Yeah, sorry, I was thinking for 1 second. Yeah, I do. I mean, the cost and burden on the government, the cost and burden on the private parties, the fairness, efficiency, accuracy, timeliness of proceedings. I mean, I think those are all the considerations that are sort of present in the report and highlighted by the draft recommendations at the end of the report that I submitted. Obviously using different words, but I think that captures, everything I can think of that would be relevant.
Yeah.
I think
I mean, go ahead.
on our end, I think when we ask agencies to consider the following factors, there's basically 2 ways to do that. We went back and forth of exactly how to phrase it. And we could say that agencies should consider, among other things, the following factors, or we can have a catch-all in the end, because we have so many different types of proceedings, and we do want to allow agencies to see that they should consider also the relevancy of their own proceeding, their own case, their own particularities. And there's a few ways to capture that, but that's only one way to have a catch-all in the end.
Sorry.
It's okay. Go ahead.
Yeah, I don't, this, I don't feel strong about this, but I can imagine at the plenary, having sat through these things many times, someone saying, why are we saying to agencies, consider the things you normally consider, right? Like, or, like, because what we're really saying is the status quo is you're considering lots of things already that are specific to the procedures that you're involved with. But we're saying, in addition to those things, focus on these other things. And so it's weird to say, focus on the things you should be focused on. Oh, and then focus on these other things. Just, I can, I don't have a strong feeling here. It seems like extra language that doesn't really convey anything meaningful relative to what we're, so that, again, like, I'm not going to die on this hill. It just seems like extra wording to me.
Sure. Ben, do you want to say anything?
Yeah, this is something we struggled with as we were drafting it. And I mean, I think like one thing, if I'm compelled to come up with an example of something that might be captured by that last subparagraph D. I mean, the recommendation later on deals with like proactive disclosure, kind of like public availability of information. I mean, I think like, you could imagine having an agency or an administration that has like commitment to like transparency, broadly speaking, and might want to make, a wide variety of agency materials publicly available on a proactive basis, even though there isn't like a clear kind of cost benefit rationale that might say like, oh yeah, you should spend all this money to set up the system so everybody can access it. So, I mean, I don't know if that's separate from A, B, or B or C, but just trying to get to this idea that there could be things that we're not thinking about where an agency might, even if an individual can articulate or an agency can articulate a really great basis for providing information one way or another, just having this kind of catch-all where like, if an agency has a commitment, for example, to broad transparency and wants to like proactively make a bunch of information available on a public basis, that could be a consideration.
Okay. Other comments on number 2? Okay. So moving on to number 3, we're in the heading now, internal agency procedures for making records available for use by agency officials. I'll let you read number 3. So I have an edit of my own. I'm going to take the chair's prerogative here. The sentence starts with when a record is necessary for use in a proceeding, and then in the very next clause, it completes with when needed for use in agency proceedings. It struck me as repetitive. So I would strike out the second one. Are there other comments on number 3? Jillian.
Just since we changed number 1 to needed for use, maybe we should begin when a record is needed for use to keep the consistency.
Good. Bernie, I guess that was what you were going to say. Okay. Okay, good. Jillian, do you still have your hand up? Do you have more? She doesn't. Okay. Anyone else on number 3? All right, number 4 on request and return. Strikes me as non-controversial, but all right. So number 5, which relates to pre-populating submissions. Let's take a look at that. I'll give you a minute to read it. Nothing?
I just continue to have concerns about fitness for purpose. One agency gathering information and another agency thinking it's appropriate and relevant, but it's not. And I don't know how to get that constraint in. And I will say, I'm thinking specifically about an example, and some of you have been on other calls with me, that happened in Australia, a scandal called robo-debt, where the Health and Human Services Agency used tax income information to determine eligibility for a family tax benefit. And they did not use it in the manner in which it was gathered by the tax agency, and it resulted in a 3.2 billion payment from the government to the people who had been harmed by this application of the information.
So that seems to relate to
I mean, you know, you think
the or another federal agency language at the end of this. Is that?
Yeah. It's previously submitted by the part maintained by that agency. Yeah,
It's really the or another federal agency.
Yeah, it's the sharing, and I know I see the language about feasible and appropriate and relevant information.
Mhm.
But in that instance, you know, tax information is relevant. It's possible to get it to the other agency. It's income information is appropriate for determining eligibility for a benefit. It's just that it wasn't used appropriately.
Mhm. Margaret, do you want to comment on this? Go ahead.
Yeah, thank you. Nina, I completely share your concern. And yet there are instances where interagency data sharing of that variety has been beneficial to applicants, right? So like FAFSA is a really good example. Obviously the rollout was rough, but now, right, so folks don't have to go obtain tax return information that they may not still have copies of in order to sort of fill these applications. So I'm just trying to figure out what the right, I totally agree with your concern. I'm trying to figure out like how to distinguish
That's a
between
good
them.
example because, and I was actually involved in that whole event. I mean, you know, the original getting that information over to the Department of Education from the IRS. And there you do need, and I do have some comments in the preface about the way that's conveyed, because it's with the taxpayer's consent that that information is shared with the Department of Education. So I think that also goes to the appropriateness. Like if you're positing the sharing on the consent of the individual whose application is going to be filled, that's a completely different picture than the government, you know, using one government agency's information for another government agency's convenience without getting the individual's consent. And they could say no, because it's not appropriate for this particular application. So maybe that's the language that I need, you know, with the consent of the party, be in there, that might be some kind of protection against an agency using information that's not fit. for the purpose. Again, that's precisely what FAFSA is doing. Is that the only way the Department of Education is able to put it into FAFSA is that under 6103C, the taxpayer consents to the release of that information.
I'd suggest that if you're going to insert, I'm just speaking to the typist, that with the consent of the party might go below, between or and another. Yeah, I think I would put it there if it's to go in this. I think that is where it would go.
Yeah. Yeah, because I think if the agency already has that information, if it has the information from its own records, then it knows what its use is, what its limitations are, et cetera.
Right. Bernie, are you on this point?
Yes, absolutely. I think the concern Nina raises is very important. And it seems to me that should actually just be a separate point at some point in here, that when agencies are using records from other agencies, they have an obligation to make sure they're using it competently or well, they have an obligation to use it in a way that is appropriate for the determination. So I think that's an important affirmative obligation for an agency to really focus on if they're pulling stuff from other agencies. And that would be, featured prominently, it seems to me.
I
And I'm
would
not
suggest
with
that we
permission.
put that in the next chunk, actually. I don't want to cut you off. Finish your,
Yeah,
you inspired me to something, but please.
Yeah, sorry. I just wanted to say that I like the with permission, but I don't think that fully addresses the point that you made, which is just an excellent.
I would suggest that for the next chunk, which we're not to yet, which is interagency agreements for sharing records, that we make that interagency sharing of records and that we have a separate numbered paragraph there that addresses this issue. Because I think I'm hearing that several people have this view. So leave with the consent of the party and let's finish talking about number 5. And then when we get to the next subheading, let's talk about putting in an actual different number 6 or, something, a separate numbered item there. Are there other comments on number 5 about supplementing submissions with information the agency has on hand and with consent from other agencies? Okay, seeing nothing. The next thing is on interagency agreements for sharing records. And I guess what I would suggest in response to Bernie and Nina is that we actually consider changing that to interagency sharing of records so that it can be broader, right, than just agreements. One of the points is there should be an agreement, but the other point might be this concern that Bernie and Nina have articulated. And I don't know if you want to propose language for that, what that freestanding principle is. One of you that you would want to suggest? I'm thinking Bernie, maybe. Do you have a suggestion for what that might be?
Sure. So I didn't have quite time to.
No, that's okay.
But I would say something like agencies should ensure that information used from other agencies' records is used appropriately. And I might also add something about the need to consult with the agency from whom they've gotten the documents to make sure they're doing so.
Maybe consult with the sharing agency to ensure the records are fit for the purpose, intended, or use by the requesting agency. And I think that fit for purpose language is really important.
Could we add it to when the records are regularly needed for use in and fit for needed for and fit for the purpose of use in? Could we add it just to number 6? To share records when the records are regularly needed for and fit for use or something like that. And
I think what Bernie's trying to say, and I agree with him, is that it needs to be an affirmative
okay.
Obligation of the agency to do that homework before they even contemplate entering into an agreement. That they have those discussions with the other agency and do that homework before reducing it into an agreement. Once they've arrived at these are records that we need.
Mm-hmm.
I mean, maybe that's the way to frame it is, agencies should consult with in contemplating entering into an interagency agreement for the sharing of records, agencies should first consult with the other agency to determine whether the records requested are regularly needed and fit for the purpose. And then you go into, when you enter into this agreement, you should do the following.
Yeah. Did the person typing, can you do that? That would be number 6.
Can you repeat that, please?
Yeah, make it number 6, a freestanding one. And Nina, can you say it again?
I knew you were going to do that.
It was very good.
An agency should consult I think I said, in contemplating.
Yeah, you started off with when considering entering into
an interagency agreement for sharing of records. An agency should consult
entering into
with the
entering into
considering entering into an interagency
agreement for the sharing of
records. An agency should consult with the sharing agency, I don't know what else to call it, to determine the records that are regularly needed for and fit for use in administrative proceedings regarding benefits or services. Or, something like that should come to determine the records in the hands of the sharing agency, the records.
Well, let's wait, stop for a second.
And people go at it.
Yeah.
I don't know whether that's doing what we want, except we want them to consult.
Right. I think we can wordsmith it a little bit, but I might suggest, and don't type this, just hear me out. Something like when considering whether entering into an interagency agreement to obtain records from another agency, an agency should consult with the sharing agency to determine whether the records will be regularly needed and would be fit for use in its proceedings or something like that. I mean, we're going to have another meeting probably. We're moving quickly, but we won't finish. We'll have another meeting and we'll have a chance to look at the phrasing. But are there reactions to having a freestanding affirmative obligation to consult on the fitness for use.
Margaret suggests source agency rather than
Oh, good.
agency, which I really like.
Mm,
Source
okay.
agency.
The source agency. For, yeah, rather than sharing, source. Margaret, is there a word for the other agency, an adjective? Is it the,
Receiving agency?
okay, that's good. So, a receiving agency should consult with the source agency. Okay.
I think overall this is really helpful though. Thank you, Nina.
And maybe put a for use in its administrative proceedings, right? Because we're focusing on the receiving agency. So comments on number 6 now that we have in front of us, this new number 6. Concerns about adding it, or thoughts about edits? I think it's very helpful. Yeah, Bernie.
Yes, I like it. I think I would try to add the concept, not only that it's fit for the purposes of fit for use, but also that it is actually used appropriately. So it might be fit for use when used appropriately. Um, so I think that's important. So I think it's important for the agency to consider both of those aspects.
So when it's considering entering into the agreement?
Yeah, so that the records are fit for use in the administrative proceedings and will be used appropriately.
Okay.
Or how it will be used appropriately.
Right, because the source agency may say, this information is for this purpose, but to use it for your purpose, you have to understand these things, or you can't, infer this from it or something like that. Yeah, so you're trying to create a dialogue.
Yes, I agree completely.
Mm-hmm.
That's what I was trying to say.
Yeah, I think that language, I like that. Yeah.
Does the regarding benefits or services make that sentence confusing? Would it be better to take that out and just say that are regularly needed, fit for use, and will be used appropriately in its proceedings? Let's try deleting the the regarding, yeah, and just.
Well, I think though that this whole section is talking about sharing. If I understood Margaret's, at least her personal viewpoint, that interagency sharing should occur with respect to applications for services and benefits, but not necessarily for enforcement. That raises all sorts of other issues.
Okay, so if that's the committee's the preference here for this, I think it's just the placement of that 4 words was throwing me off. How about putting fit for use and will be used appropriately? Move the and will be used appropriately up, and then put the and then put the regarding benefits or services at the end again. Yeah, that's what was throwing me off. I got lost in the sentence. Or services, yeah. Okay. Does that work? Still a little clunky. Anyone?
Yeah, I think that works.
Okay. All right, number 7, formerly 6, now 7, should enter into an agency agreement. In those situations, I think you probably want to have uh, wait, I wasn't giving you language. I was just paraphrasing what was in front of me. I'm sorry. Should enter into an interagency agreement to share records. And this repeats some of what's in number 6. So number 6 is when considering this, the agency should consult. And number 7 is a normative should enter into an interagency agreement when. Should it parallel what appears in number 6?
I think what it's added is the additional restriction that the agency doesn't already create, collect, or maintain them.
Mm-hmm.
You know, you should be doing the consultation because you might find that their records are actually the other agency's records are more on point for determining benefits, even though you might have some information. But once you get into an agreement, you really have to establish that you don't have these records.
So do people have any edits to this, to number 7, or suggestions?
Maybe outline and describe the appropriate use fit for the, let me see, needed for and fit for, no, and fit for the use. That's fine. Yeah, I think that's okay.
Bernie, don't forget to put your hand up. I don't always see the chat bar. I've got 2 screens and I see the hands when they're raised, but the chats are off. So thank you. And plus it makes a little popping noise.
So a suggestion with regard to fit for the use, maybe we should say fit for the contemplated purpose. Would that help? And again, don't feel strongly about it.
An agency should enter into an interagency agreement, share records when the records are regularly needed for, and say it again, and fit for the
fit for the contemplated purpose.
contemplated purpose.
I like that.
Oh, then the rest of it's got to be fixed.
Right, and then and the agency receiving the records does not already create, collect, or maintain them. Does that? Bernie, okay. Nina, reaction to that?
That's fine.
Okay.
Yeah. Yeah, thank you.
Anyone else have comments on former 6, now 7? Okay. Moving on to number 8. Consistent with recommendation 2012-5, improving coordination of related agency responsibilities, an agency should make interagency agreements for sharing agreements. I think that's a mistake. I think that should be sharing records publicly available and regularly assess their effectiveness. So it should say interagency agreements for sharing records. Bernie, is that an old hand or a new hand? Thank you. That's what I get for asking you to put your hand up. Anyone else? Okay. Procedures for parties to obtain records in agency adjudications involving an evidentiary hearing. Formerly 8, now 9. I'll give you a minute to read it. I see no hands. Nina.
Sorry to keep popping up, but maybe this is where my concern about unrepresented, parties could obtain their own records that have been submitted. That could be a separate paragraph here. I don't know whether it applies only to evidentiary hearings.
So what are you envisioning? Help me out a little bit more.
I'm envisioning another paragraph that says an agency should, the first paragraph is talking about inspecting unprivileged materials. I'm just trying to find the place to fit in my concern about unrepresented parties submitting information to the agency, but then not retaining any record of it themselves, and they're being able to get that information from the agency that they've previously submitted.
Well, there's an entire section on online self-help portals for parties to obtain records about themselves. Do you think that might be? I mean, I guess that's about decisional documents. You're talking about things people have submitted themselves and they did, like my tax
It
forms.
may have been at an earlier stage of the agency hearing process where they were unrepresented, and then they finally at a later stage are represented. And with some agencies, they will not, even in FOIA requests, they will only provide information other than what the taxpayer has submitted. That's the default.
Okay.
So
this is for, I guess what I would suggest is this clump is for procedures for getting records when there's a hearing. I think your concern doesn't comfortably shoehorn here, because I think you want to capture other scenarios, not just adjudications involving hearings. And I guess there might be another place. It may end up going in the final one under other considerations, because we do have a catch-all where, so it might actually go there. So let's keep the pin in this. And I think we come back to it when we get to the set of things that could not be put into one of the other subheadings.
Okay.
Let's just not forget it. Okay, so any other comments on number 9? Okay, the next heading is procedures for parties to obtain, sorry, it's not, it's procedures for parties to submit individual requests for records. I'll let you read number 10. Let's see if there are comments. I think that just it will read a little bit better if we have singular plural agreement in this. So I would change it so that it says written procedures for parties to submit individual requests for records that are regularly needed. And that's going to align. And then if other procedures for obtaining the records. All right. But putting those little edits aside, are there comments?
Maybe this is where you can just say, including records that the party previously submitted. Agency establish written procedures.
Yeah, and that's exactly where, yeah, right after proceedings.
Records. And that way, if you can't get it, if the agency is not normally giving it to you under FOIA, they have to create a procedure where you can ask for that.
Mhm. Maybe make that parties plural, just so we're being consistent. Anyone else? Bernie?
This seems to have a subtle suggestion that we prefer to have people go through FOIA rather than through an alternative process. And it seems to me there are problems with going through FOIA because then you get thrown in with all the other people making requests for records for other reasons. So should we say something like, let's see, an agency should establish written records for parties to submit. If other proceedings for obtaining records, sorry, unless other proceedings for obtaining the records are sufficient or um, or warranted based on the factors described in paragraph 2. So that's drafting on the fly again is difficult, but I would want to make the default providing the records outside of FOIA rather than providing them through FOIA.
Other reactions to that? Okay. Hearing none. How about number 11? Bernie, do you have your hand?
Oh, sorry.
It's okay. Publishing the procedures just described in the Federal Register, codifying them in the CFR, specifying the records that can be requested and how the agency will review and respond, including timelines, and whether the party can get review by a higher level agency official. No comments? Okay. Number 12. Oh, Jillian, is that on number 11 or?
No, number 12.
Okay. Go ahead.
it's just the same point I made before. We've got the older language necessary for use here and in the new 13, so we should probably be consistent. Make it needed for use.
Thank you. Anything else on number 12? Okay, what about number 13? Jillian had that one as well, so that necessary should also be changed to needed. And then anything else on number 13? Okay, so I have 4 minutes till the hour, so we've been on for an hour and a half, and it is a 3-hour meeting. What do folks think about only a handful of people I can see who will nod or not nod, but about a 5-minute break for biological necessities? Very good. All right, so let's come back at 5 past. Okay. Hopefully everyone is back and refreshed. So let's pick up. We're in the subsection now called I'm trying to. We are on number. Scroll back up. We did not do. No, we did. We did that one. I'm sorry. Online self-help portals for parties to obtain records about themselves. So newly numbered 14. An agency should consider establishing an online self-help portal that allows parties to obtain records about themselves when parties regularly request specific categories of records for which little or no redaction is necessary. Are there comments? Concerns? Edits? Okay. Moving on to 15. Nothing. Okay. Proactive public disclosure. Number 16, an agency should consider making records publicly available beyond what is required by law, and such records would be useful to parties in administrative proceedings, including decisions and filings associated with prior adjudicative proceedings, consistent with a prior recommendation from ACUS. Their comments on this. Yes, Bernie.
Yes, so with this, I thought that the recommendation we did on proactive publication of agency legal materials would also be a relevant citation here. I think we covered that in that recommendation. And Margie, you did the adjudication parts of it, so I would
That's
defer to
a
your memory on it.
that is totally true and completely correct.
So does someone from ACUS want to weigh in on whether there's an additional recommendation that needs to be cited here?
Yes, I think we were contemplating our understanding of that recommendation is that the recommendation details there are directed to Congress and not to agencies, and this recommendation is for agencies and not Congress. Definitely the report and the underlying principles in the recommendation are relevant here. There was this distinction that the recommendation itself was aimed to Congress and not to agencies. I'll let the committee decide how you want to handle this, but this is why we did not include it in the language here.
Okay. Barney, any reaction? Does that make sense, or do you want to handle it, mention it anyway?
I mean, it makes sense, and I would defer to A because I have a question like this, so I'm fine.
Okay. Anything else on number 15? Or sorry, 16? Okay, number 17, when an agency proactively makes records publicly available, it should organize and index such records to allow parties to locate the information they need more efficiently. Comments, concerns, questions? Go ahead, Bernie.
Yeah, just one. Do we need them more to locate the information they need more efficiently, as opposed to information they need efficiently?
Okay, so
And
that's
more efficiently than what?
right. Okay, good. Anyone else? Okay, I'll move down to other considerations. Bernie, you might drop your hand. Other considerations when making records available in proceedings. Number 18, when not prohibited by law, an agency should consider using informal or ad hoc methods for making records available, if doing so would avoid reliance on more costly methods for obtaining the same information, such as providing an explanation for an agency decision by email, rather than requiring the party to file a FOIA request for the same information. Are there concerns or comments or proposed edits to this? Nothing? Okay. Then we'll move on to 19. To the extent, I'm sorry, My numbering on my page in front of me is different from the one on the screen. Number 19, an agency should not charge fees for requesting and obtaining records for use in administrative proceedings unless such fees are required by law. No comments, suggestions? Okay, number 20. To the extent practicable, an agency should design its records to enable faster disclosure, whether upon request, through a portal, or an online database, or on an online database, such as by allowing automatic redaction of private information. Are there thoughts on this one? Okay. This is swift movement through the recommendation. All right, so then we have number 21, which is the last one. And then I think we'll have Nina's point. We need to come back to Nina's point, which I think is going to go in this under this heading. Number 21, an agency should, to the extent practicable, recognize records produced by the agency or other federal agencies as official records sufficient for use in their proceedings. I expect there will be some hands on this one, but perhaps not. Are there concerns, considerations? Yeah, Bernie.
I just have a question for information here, which is I didn't see anything in the report that referred to this, and I might have missed it, but where is this coming from? I mean, it seems a perfectly reasonable suggestion, but what's the origins of this?
Hey, Al, do you want to explain the origins of this? Or someone else from ACUS?
Maybe Margaret can in here, but I think the example that we had in mind is in certain immigration proceedings, there is some records that are obtained by one agency component at DHS and not automatically recognized as official for the purposes of the other agency component. And I think that creates some inefficiency that we wanted to address here in this recommendation. I don't know if that reflects your report, Margaret, if you have any opinion here on that.
Well, yeah, this recommendation didn't stem directly from a recommendation that I made in the report. So I defer to Ayal's description of sort of what the thinking was behind it. I can say in the immigration context, I do think it's complicated because some components of DHS have attempted to facilitate quicker disclosure of some immigration related information by disclosing non-official copies of certain things that then can't be used for certain other purposes. That, of course, on the one hand, seems like it should be applauded because they're trying to facilitate quicker access. On the other hand, creates difficulties because that record can't be used for many other purposes. So I guess one question is recognition of records that were never intended to be official. That's not really, that seems unlikely, right, to be successful just because. So maybe the maybe it could be better phrased as like records should be produced in an officially recognizable way. I don't know whether that's the only example I can think of. Ayal, maybe you have others. The only example I can think of is that CBP has this database for I-94 information that basically is entry and exit data from the country, and you can get a report generated from that that can't be used as like proof in immigration court about presence or anything like that. So but it's an online tool, so you can get it immediately, a certain amount of information. It's not entirely complete. It's not available for all kinds of all categories of non-citizens. So there's also the limitations on it, but that record isn't an official record. So that's the example I'm thinking of that falls in that category. Ayala, did you have anything else?
No, that's the primary example we had in mind. I cannot think of another example that we had when we were at justice.
Okay, thanks for answering my question.
Great. Thank you. Anyone else on this one? Yeah, Nina.
I guess given that discussion about the immigrant, I have concerns about, I like Margaret's recommendation of basically changing in a way the thrust of this, which is that you should be sharing things that can be used as that are official records, recognized records, official records. And I don't think we should be encouraging agencies to do end runs around protections that individuals may have because one part of an agency or in order to use unofficial records in ways that they were not intended to be used. I'm a little disturbed by that example. I'm not sure we should be encouraging that.
Are there reactions to this? It sounds like this might actually be a different sentence, a different affirmative point that agencies should be producing records in don't make any edits. I'm not suggesting language. I'm saying it sounds like a different substantive point is being proposed. Jillian.
Yeah, I guess this one, I guess I feel a little bit concerned that there could be a broad universe of different reasons why agencies don't necessarily currently recognize records that are produced as official records. And I don't know that I feel fully informed enough to think that we should be strongly recommending that they translate them into official records. I understand that Margaret's explanation was very helpful about if you're going to be issuing them, then you got to recognize that they're going to be used as official records. And I understand the disincentivizing force of that, but it just strikes me there could be a world of action out there. I'm not sure that I feel like I've got a good handle on what it might be.
Margaret?
I will say, given that between Ayala and I, we can come up with exactly one example, I wonder whether a generalizable recommendation to address sort of one specific thing that came up is appropriate. One option is to simply not speak on this issue simply because this issue did not come up in some, I mean, maybe this goes directly to Jillian's point, right? Did not come up in a systematic way enough for us to know if there are potentially sort of exceptions or countervailing considerations that we might want to consider, or how to craft a recommendation a little bit like, is it the nail looking for the hammer? What's the analogy? There's something like that. Yeah.
I think that's the analogy.
There it is. Yeah, great. I'm not that great at the sayings.
Yeah, Bernie?
And if records are being produced that can't be used officially, I assume they are labeled as such. If they're not labeled as such, and a party thinks they have a record they can use and they can't, that's a problem. So I think agencies should definitely be properly labeling them so that parties to proceedings aren't misled. Second of all, it seems to me that a reasonable principle would be if you're going to provide documents and information unofficially, then you ought to have a procedure for providing that document on an official basis in an expedited manner if requested by a party to an adjudication. So that allows for agencies to do what the Customs and Border Patrol is doing, and I won't second guess why they're doing it. But in the context of adjudication, there needs to be these protections so that it's just fair to people who are participants in adjudication. So I would be inclined to perhaps think about a recommendation along those lines.
Okay. Are there more reactions to this? I'm hearing two different things here. You know, maybe we should be adding something which either says something affirmative about an agency's obligation. Maybe it's you must do official, or you should specify what it is, and then thoughts that we should just leave this as is. Jillian?
I think I'm inclined to just say it'd be better to maybe just remove this one. I have a sense that we're going into other territory here from what the focus of this has been. And the substance of the recommendations might be good. I haven't got a position at all. I'm not opposed to the substance, but it just strikes me that maybe we should just focus a little bit more closely on what this report and this undertaking is about. And this seems a little bit beyond.
Yeah. Other views on this? I do think it's a little bit not covered, although I sympathize personally quite a bit with the concerns. I feel like it might not have been really part of the focus of Margaret's study, but this labeling of things as official or unofficial. I mean, I guess I'm inclined to think Jillian's right that this is, although perhaps meritorious, not the focus of the report. But are there other reactions? Bernie, how do you feel about taking does taking off 21 and pushing that topic to a sort of separate consideration? Is the concern that you've identified sort of teed up by 21, and does it go away if we just stop talking about it, or do you still have it? Question makes sense?
It does. I think there are very valid points that we haven't really sufficiently studied this and we don't know exactly what's going on. That's resolved by just removing paragraph 21. And I don't need to add the points that I suggest. I mean, I think they are good points, but just to consider the whole subject beyond the scope of this is fine with me.
That gives ACA something else to put on their to-do list if they want. Okay, so that takes us to the end of the recommendation. The preamble is 3.5 pages. And I know that there are, Jillian, do you have your hand is still up? No, okay. So let's go to the beginning of the recommendation, or I'm sorry, Bernie, is this still in the recommendation, or are you talking preamble?
We were going to add
Oh my gosh,
a point
yes.
to Nina's.
Thank you. I am so sorry. Thank you. All right. So we're deleting this, and then so delete the one about official. Yep. And we're going to put in a new 21, but we need to talk it through first. So Nina, now you're up.
Here's my moment.
Here's your moment.
Yeah, and let's see if I had tried to come up with some language, but I'm not. I, I, I haven't framed this, but I think it's, maybe it's something like don't write this down. I'm just going to run, in responding to a request for records, an agency for records which a party has submitted to an agency, the agency should consider, among other things, the unrepresented status of that party. In deciding to provide those records.
And is your thinking that if the party is represented, they shouldn't get the records?
Well, no, I just think that that's a factor that they should. And I actually have to say that I thought that we kind of addressed it earlier on. I felt there was a paragraph, I don't have, the corrected one in front of me, but we added some language that I was actually pretty happy with earlier.
Well, maybe it makes sense then, between the first and the second meeting, when we all get a clean copy for you to read through it and think about whether you still have that.
I will do that.
Okay.
Yeah, thank you. And thank you for keeping that pin in, everybody. I really appreciate it.
Okay. Well, so then let's go to page 1, beginning of the preamble. And we can just go sort of, I think, bit by bit. So we'll start with the first, it's a very short paragraph. So let's look at maybe both sentences here, lines 1 through 6, and just see if there are comments or concerns. Now, I do have a question here. This is that the first sentence, which refers to enforcement actions, suggests the scope is as broad as enforcement actions. And when we did the recommendation, in several places, it is focused on administrative proceedings regarding benefits and services. Those were, I believe, the recommendations that related just to sharing of records. And I just want to make sure everyone is clear that that distinction has been drawn. And Eyal, I'm understanding that correctly, right?
Yes, you're unclear. That's right.
Okay, very good. Are there questions, comments on these first 2 sentences, this introductory paragraph? Yeah, Bernie.
Quick question. An application for a permit that could take on some of the characteristics of an enforcement action if there's some information from another agency that gets pulled in by the receiving agency. So part of the concern with limiting it to benefits and that sort of thing was that we didn't want extraneous information from another agency's files to be used to harm that individual. So do we have to be concerned about that in applications for a license or a permit? And that's largely a question.
Right, and I guess that really goes to the drafting of the recommendation and whether when we had the language, and I guess it's sort of 7 and 8 of the recommendation relating to the sharing of records, whether we should be saying something about the fact that even some of the proceedings relating to benefits, is that the concern? Some of the things that we actually are addressing there, we're similarly concerned about the record sharing. Am I understanding correct? I'm trying to understand what the comment sort of leads to in terms of drafting of things.
So I think that's probably right. And by seeing this listing, it just occurred to me that there may be some things we kind of think of as benefits, but actually have the same sorts of problems we were concerned with in trying to make this distinction between benefits proceedings and enforcement proceedings. So really just wondering whether we have to worry about that, whether we need to be more precise in the recommendation or define our terms better. And if we're going to split enforcement off from these other things, do we need to be more precise, or is what we have basically good enough?
Okay, Margaret.
I guess I was just gonna ask Bernie sort of, I mean, the concern is certainly there, right? The information that you could get from another agency might harm the applicant in some way in a licensing or permitting decision. But I think that's true also for any benefits or services you're applying for, right? It's possible, think about an individual seeking some sort of means tested benefits. Let's say they consent to grabbing their information from the IRS so they don't have to go get their tax returns. Well, it's possible that information actually shows they don't qualify, right? Like that is amongst the possibilities. So I guess my question is that different for licenses and permits in a way that that's not true for that or is that concern present for all of these, and sort of our later incorporation into the recommendation about consent sort of handles it across the board, which I think was Nina's excellent addition.
Good question, which I haven't fully thought the answer through, for which I haven't thought the answer through. I do see your point that this would apply more broadly to even things that don't involve licensing. So yeah, I mean, maybe the distinction with enforcement actions is it's a penalty as opposed to a benefit that's being withheld. Um, so I can live with that, but I just wanted to at least raise the question in case there's some sort of issue about what exactly is the distinction between the enforcement proceeding and benefits, and whether the same concerns we had with regard to enforcement proceedings are actually present in with regard to benefit or at least licensing determinations.
Right.
But I think that sufficiently probably answers it.
Okay. And I think the consent piece that we added is helpful on that, as Margaret says. Okay, so we are now down to the second paragraph. So let's look at maybe the first 2 sentences here. Actually, maybe we'll read the whole paragraph. It's only 4 sentences long. Any suggestions, anything concerning in these 4 sentences? Forward to lines 16 through 19. All right, seeing no comments here. We have lines 20 to 25, 3 sentences. No comments on this? So I think, although it's 9 lines of text, I think we probably should take 26 to 35 as a whole, because this is the paragraph on agencies obtaining records from other agencies, and I think we'll probably end up wanting to talk about what's described in here. So let me just open up all, it's 1, 2, 3, 4 sentences. So let's maybe talk about this discussion of agencies obtaining records from other agencies and see if there are comments, concerns about the wording here. Nina?
Yeah, I would just something very specific, the paragraph about the Department of Education, I would say we need to get the consent issue in there. For example, with the consent of the taxpayer, applicants for the Department of Education, FAFSA, can pre-fill answers to some questions by automatically transferring. Or maybe leaving the sentence, but the Department of Education allows applicants to pre-fill answers on FAFSA. Yeah, you have to, somehow we have to say, upon consent of the taxpayer. Maybe by using a consent-based information sharing process.
No. It's the next line down.
It's the next line. Yeah. By using, their federal tax return information.
Using a consent-based. Bernie?
Yeah, what about just adding allows, for example, Department of Education allows applicants who consent, that would be the addition, to pre-fill answers to some questions.
Yeah.
Margaret?
Isn't the problem with that the applicant is usually not the taxpayer or the parents who are consenting?
Yeah. Yep. Yep.
Okay.
So I don't I don't have a solution. I'm just creating more problems.
Yeah.
Yeah.
Well, I just think that flagging that consent concept is important.
I think consent-based works perfectly. I think we don't, yeah. I think that's true and important.
Except I have a question here. Your point that the applicant is not the taxpayer, I hadn't focused on, despite having gone through it recently. Because it says automatically sharing their federal tax return information, the word "there" is referring back to the applicant. So I think we have a problem. I think it is to pre-fill answers to some questions.
Their families, federal
Yeah,
tax return information.
applicants and their families.
Yeah. You could just maybe say relevant federal tax return information, because it is sort of complicated there. It's their own tax information. It's also the parents. I imagine with more complicated family situations, it may be multiple individuals. I don't know. But as long as it says consent based, I think that might be the best way to do it.
You take out the pronoun, yeah.
Other edits or comments or concerns with this paragraph on sharing of information? All right. If we move on to the next paragraph, this is kind of long. I think we should take some time to read it. This is about private parties to agency proceedings. So let's take the first sort of 36 to 42, the first couple sentences. Just make sure there's nothing here. One question I might ask is whether we want to rephrase the first sentence. Don't make any changes, just I'm mindful of the fact that we talked about records being needed rather than necessary, and I don't know if maybe rather than private parties to agency proceedings may be responsible for obtaining the necessary records from agencies, for providing them to the agency or for their own use. Do we want to say, does that need to be rephrased to match the more broad sort of private parties to agencies proceedings may need records from the agencies? Jillian.
Yeah, I think that, again, just consistency needed would take care of it.
And maybe even get rid of the may be responsible for and say may need to obtain records from the agencies, Yeah. To obtain records from agencies. Yeah. So then it's needed records. Anything else through, say, line 42, the end of the second sentence? All right. And then the last three sentences, which is 42 through 49, cover situations when discovery is circumscribed or unavailable. Margaret.
Line 44 has another necessary that should be needed.
Good. Anything else with this paragraph? Let's look at the next paragraph. Let's the first two sentences. We can just do 50 through. Oh, okay. You can show the whole thing on one screen. Thank you. So it's 50 to 57. Anything? All right, that brings us to the final paragraph of the preamble, 58 to 64. Nothing.
Is it shared or transferred when records are transferred between different agencies or agency components? Do we want to, we haven't really used transfer. We've used the word shared. When records are
That's
shared.
right. We have used shared. Is there, Margaret, is there a substantive reason why this should say transferred? You're shaking your head.
I think shared is appropriate.
Okay. So let's make that shared. Thank you. Good catch. Anything else? Okay. Fantastic. So, the next steps, there will be a new clean copy of the preamble and the recommendations sent out to the committee. And there's a pretty long break between this meeting and the next meeting, and I apologize for that. I had a bunch of travel. So it's actually not until October 20th. It'll be fresh in everyone's minds again. I'll have to reread everything closely, but a break for 5 weeks. Is there anything else I need to do, or is that it? That's it, right?
I think that's it.
Okay, well, thank you everybody for making this such a painless meeting, and we will get something clean out and see you in 5 weeks.
Thank you.
Oh.